Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts This Week on Live Law, where we update you about all the important legal developments that took place across the country last week. We will begin with developments from the Supreme Court of India and then move on to High Courts and other subordinate courts. If you like our content, then please do support us by liking and subscribing to our YouTube channel. Let's begin. Amidst the speculations about the Supreme Court collegium meeting held on September 30th, a joint statement has been released by the Supreme Court collegium members stating that the said meeting has been discharged in view of the Union Law Minister's letter to the Chief Justice of India, UU Lalit, on October 7th asking him to name his successor. As per the statement, two members of the collegium, Justices D.Y. Chandrachud and Abdul Nazir, raised an objection to the letter circulated by CJI Lalit seeking their views regarding proposals for elevation to the Supreme Court. The two judges objected to the process of selection and appointing of judges by circulation. The Supreme Court of India has observed that the state of West Bengal usurped the powers of the Chancellor, that is the West Bengal Governor, while reappointing Sonali Chakravarti Banerjee as the Vice Chancellor of the Calcutta University. Holding so, the Supreme Court dismissed the petitions filed by the state of West Bengal and Banerjee assailing the order of the Calcutta High Court, wherein the decision of the state to reappoint Banerjee as the Vice Chancellor of Calcutta University had been set aside. In a significant judgment, the Supreme Court has held that no offence for dishonour of cheque under Section 138 of the Negotiable Instruments Act is made out if the cheque is presented for the full amount without endorsing the part payment made by the borrower after the issuance of the cheque. The court held that the sum reflected on the cheque will not be the legally enforceable debt as per Section 138 of the NI Act when it has been presented for encashment without endorsing the part payment. Part payments must be endorsed on the cheque as per Section 56 of the NI Act. The Supreme Court has dismissed the petition filed by the Enforcement Directorate challenging the Bombay High Court's order granting bail to NCP leader and former Maharashtra Home Minister Anil Deshmukh in a PMLA case. A bench comprising Justices D.Y. Chandrachud and Hema Kohli, however, clarified that the observations made by the High Court will not influence the trial and are only confined to the issue of bail. After hearing the petition elaborately for over 1.5 hours, the bench said that it will not interfere with the High Court's order. For context, Deshmukh is under custody since November 2nd last year when he was arrested in a money laundering case related to alleged collection of bribes from bar hotel owners in the city of Mumbai. The Supreme Court bench comprising Chief Justice UU Lalit, Justice Ravinder Bhatt and Justice Ajay Rastogi listed a batch of petitions challenging the constitutional validity of the provisions of the Places of Worship Special Provisions Act of 1991 on 14th November. The court also directed the Union of India to file its response by 31st October this year. The petitions have been filed against the Act inasmuch as it bars remedies against illegal encroachment on the places of worship and pilgrimages prior to August 15, 1947. Persuaded by the petitioners to change its preliminary view that the challenge to demonetization has become an academic issue, the Supreme Court of India has commenced hearing the legal arguments raised by the petitioners on merits. A constitution bench comprising Justices S. Abdul Nazir, B.R. Gavai, A.S. Bopanna, V. Ramasubramaniam and B.V. Nagaratna is considering 58 petitions which challenge the decision taken by the central government to demonetize the currency notes of Rs 500 and 1000 denominations. While Attorney General for India R. Venkataramani and Solicitor General of India Tushar Mehta repeatedly asserted that the issue had indeed become academic because of the passage of 6 years, senior advocates P. Chidambaram and Shyam Devan, on the other hand, contended that the validity of the government's decision was still open to challenge. In a significant development, the Supreme Court has passed a split verdict on a batch of appeals challenging restriction on Muslim girl students wearing the hijab in education institutes in the state of Karnataka. Justice Hemant Gupta dismissed the 26 appeals filed against the judgment of the Karnataka High Court, which held that hijab was not an essential practice of Islam and allowed the ban on wearing of the hijab in education institutes in the state. Expressing the divergence in his opinion, however, Justice Sudhanshu Dhulia set aside the Karnataka High Court judgment and held that the entire concept of essential religious practice was not essential to the dispute in question. The Supreme Court of India has dismissed the petitions filed by WhatsApp and its parent company Meta or Facebook, seeking to stay the investigation by the Competition Commission of India, that is the CCI, into their privacy policy. A bench comprising Justices M.R. Shah and Sudhanshu Dhulia rejected the petitions filed by WhatsApp and Meta, challenging the order of the Delhi High Court Division Bench, which had refused to stay the CCI probe. The Allahabad High Court has observed that the court should not compel a wife against her wishes to live with her Muslim husband who was married again and share his consortium with another woman if the court is of the opinion that it would be inequitable to compel her to do so. The bench of Justice Surya Prakash K. Sarvani and Justice Rajendra Kumar observed thus while discussing an appeal filed by a Muslim man challenging the family court's order dismissing his suit for restoration of conjugal rights in connection with his first wife. The Delhi High Court has said that sick or infirm persons need not satisfy the twin conditions for the grant of bail under Section 45, Subsection 1 of the Prevention of Money Laundering Act. After perusing the statement of objects and reasons of the PMLA, Justice Jasmeet Singh in an order on a bail application said that the inclusion of the proviso for grant of bail shows the legislative intent to incorporate relaxations for persons below 16 years of age, a woman, or those who are sick and infirm. The Punjab and Haryana High Court has quashed an FIR against BJP leader Tajinder Pal Singh Bagga, who was accused by the Punjab police of spreading misinformation and communal disharmony and posting inflammatory statements against Delhi Chief Minister Arvind Kejriwal. Justice Anup Chitkara in the order said that the purported statement of Bagga is a protest against the statement made by Aam Aadmi Party leader and Delhi Chief Minister Arvind Kejriwal. The court also said that there is nothing to infer that his statement was so inciting that it would fall within the purview of hate speech and that it would lead to any violence or make fault lines in the structures of the communities. The Kerala High Court, while disposing of two petitions challenging the grant of anticipatory bail to the author and social activist Civik Chandran in a sexual harassment case, expunged the sexually provocative dress remark of Kozhikode Sessions Court. Justice Kausar Edapagat, while disposing of the two petitions moved by the state as well as the de facto complainant against the anticipatory bail order, observed that even though the reasons shown by the court below for granting anticipatory bail cannot be justified, however, the order granting anticipatory bail cannot be set aside. In a significant order, the Varanasi court has rejected a plea moved by the Hindu worshippers seeking a scientific investigation into Shiva Linga reportedly found inside the Gyan Vapi mosque premises. The court rejected the plea in view of the Supreme Court's order to protect the spot where a Shiva Linga was claimed to have been found during the survey of the Gyan Vapi mosque. If carbon dating or ground penetrating radar is permitted and if damage is caused to the Shiva Linga, then it would be in violation of the Supreme Court order to protect it, and it might also hurt the religious sentiments of the general public, remarked the Varanasi court in the order passed. The Bombay High Court Nagpur bench has acquitted former Delhi University professor G.N. Sai Baba and 5 others in an alleged Maoist links case. The court has allowed their appeals against the conviction and life sentence imposed under the anti-terror law UAPA. The court held that the trial was null and void as valid sanction as required under Section 45 of the UAPA was not obtained. The court observed that procedural safeguards cannot be sacrificed at the altar of a perceived peril to national security. A division bench of Justice Rohit Dio and Anil Pansare of the Nagpur bench of the Bombay High Court pronounced the verdict. Thank you. Keep watching Courts This Week on Live Law for more such updates. See you next weekend.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.